Well, hello there and a very good evening. You're with me, Zulfiq Farzan, on this special edition of The Hot Seat with the former president of the Bar Association of Sri Lanka, Mr. Upul Jasuria. Mr. Jasuria, thank you for joining us this evening on Hot Seat.
Good evening.
Let me start off by asking you this one question. The president recently said, "I will never appoint Ranil Wickremesinghe again as Prime Minister in my lifetime," quote unquote. The question is, can a person, be it anyone, decide whether the Prime Minister of this country should be a person he likes, or should it be the person who commands the confidence?
The answer is fairly simple. The constitutional provision with regard to the appointment of a Prime Minister after election has no reference with regard to a person of his like to be appointed. No, there is no such provision. The person who commands the highest respect and the confidence of the Parliament is the one who has to be appointed. The best example that one can give would be when President Kumaratunga's party went into force in 2001 against the party or the front that was led by Mr. Ranil Wickremesinghe was defeated.
You are referring to the resounding victory that they achieved
in 2001. I'm sure President Kumaratunga didn't like Mr. Wickremesinghe's face at all, because she was defeated, her party was defeated by Mr. Wickremesinghe. So there is no question of the likes or the dislikes. But the most hated enemy, as he was then, of President Kumaratunga, had to be sworn in as the Prime Minister of the country, because that was the verdict of the people. That is what it all means by democracy. We have to work with people whom we dislike otherwise. Now, in fact, let me also quote Evelyn Beatrice Hall, a famous writer. In 1903, she said in one of her books, which is very world famous, she said that I disapprove totally of what you say, but I will defend to the death your right to say it. So that goes to show is not the subjective standard, but the objective standard that has to be applied in the civil society when people deal with men and matters. We can't bring in our personal ideas and likes and the dislikes and the fancies that we have. No, it is not so. There can be all kinds of, there can be so many excuses that the president can give that he is unable to work with Mr. Wickremesinghe. That's besides the issue. That has no relevance to the question that we have to decide on the constitutionality of swearing in Rajapaksa and swearing vis-a-vis swearing in Mr. Wickremesinghe.
Mr. Jasuria, on the topic of the constitution now, petitions are filed at the Supreme Court against the dissolution of Parliament, challenging that gazette, saying it's unconstitutional, and then there were interveners and other petitions supporting the dissolution of the Parliament as well. Now, when we speak of the Constitution, a question that many had over the recent weeks was the interpretation of the Constitution. There was a huge discussion, especially on social media, people giving their own versions of the interpretation of the Constitution. You were the president of the Bar Association of Sri Lanka. In your view, what is the correct interpretation of the Constitution when it comes to this matter?
Before I come to that, I will also refer to another issue with regard to the same constitution. A lot of people have also raised the fact that at the time when in 2015, when the president was sworn in as the president of this country, that the then Prime Minister, whose party had more than 152 members of Parliament in the Parliament, was sacked, and Mr. Ranil Wickremesinghe was sworn in as the new Prime Minister. Now, the constitutional provision that was there under the old constitution was entirely different. That was a provision that was there where the president has the choice of firing the Prime Minister at any stage.
At any given time.
At any given time. Now, this is the provision that was changed with the new 19th Amendment that has come in. When the 19th Amendment was brought in, there were so many arguments that were brought in by various parties, but not the parliamentarians. It's a historical amendment where 224 members of parliament voted for it, if I remember right.
Yes.
So, which is not precedented. The only time that I can remember, I can recall a similar instance was the passing of the 17th Amendment. So now we have heard from the Attorney General himself that the power that was there with the President cannot be reduced other than through a referendum. Now these are his own predecessor in office, I think it was not him, Mr. Vijaytilaka, Yohanjan Vijaytilaka, he himself went and supported before the Supreme Court, saying that this amendment, 19th Amendment, does not require a referendum. So if that be the case, 19th Amendment is now passed, it's law, it's part of our constitution. We can't give an interpretation, then we can't look at the rights and the wrongs of the 19th Amendment. We only have to give the interpretation to the 19th Amendment. Now let's look at the 19th Amendment. What does it say? 19th Amendment, I think one of the main arguments that have been brought by the Honorable Attorney General is 33 sub-article 2b. It says, the President shall have the power to preside at ceremonial sitting, the President shall have the power to summon, prorogue and dissolve Parliament. Now this is among so many other powers. That is, I was reading from 2c. Then it says meeting ambassadors and appointing ambassadors and so on. Then you go to F. F, it says the President shall have the power to keep the public seal of the Republic and, amongst others, so many other people, including the Prime Minister, and the appointment of the Chief Justice and other judges of the Supreme Court, the President of the Court of Appeal and other judges of the Court of Appeal. The President has the power to appoint. Now does it mean for a moment that he has the power to appoint these judges of the Supreme Court and the Court of Appeal on his own, without any other approval process? No. Article 41c says that the President's power to appoint is subject to the approval by the Constitutional Council. It reads thus: no person shall be appointed by the President to any of the officers specified in the schedule to this article unless such appointment has been approved by the Council upon a recommendation made to the Council by the President. So the same article, that is 33(2)(f), where the President is given the power to appoint judges, is subject to 41c, where it should be approved by the Constitutional Council. Now same way, coming back to Article 2c, where it says, I repeat the same thing, to summon, prorogue and dissolve the Parliament. Now how does, there is a subsequent article which goes on to say that it shall be done, I am reading sub-article 1 of Article 70. The President may by proclamation summon, prorogue and dissolve Parliament. These are the same identical words that were there in 2c. Provided, there is a proviso that has come in here, provided that the President shall not dissolve Parliament until the expiration of a period of not less than 4 years and 6 months. That is what we are all aware of. So there is a proviso. So it's a power that has been given in 2c is obviously has to be read with 71 proviso. The same way it has to be read with what is there in Article 2f has to be read with 41c. This 2 has to be read with 70 sub-article 1. So there is no rocket science in this. Anyone can, it's so simple reading. Anyone can read and understand that. You can't attribute a meaning to a constitution that can be construed to be a non-democratic interpretation that defeats the purpose for which it has been brought in. The purpose for which the 19th Amendment was brought in was, it was widely discussed in the public domain that it is for the purpose of curtailing the certain powers of the President, including his tenure of office from 6 years to 5 years. Now There again, His Excellency probably he was doubtful, though there was a specific, very clear provision that even the incumbent president that it applies, and it has to be 5 years.
Okay.
He quite rightly advised the Attorney General to seek the opinion of the Supreme Court, and it was sought. And the Supreme Court held, no, it applies to the sitting president, the incumbent president. So if there was any doubt at this stage, there again it was open for His Excellency the President to seek the opinion of the Supreme Court. But that was not done. That was not done. Why was that not done? So these are questions that one finds it difficult to answer. So look, now there are so many legal...
So Jasu, before we continue with this discussion, we need to go for a short commercial break. We'll be right back. Welcome back to the hot seat. We were discussing about the constitutional crisis here in Sri Lanka, and Mr. Puljasugi, the former president of the Bar Association, gave us a very articulate answer on the interpretation of the constitution regarding the powers of the president. Let's move on a bit further from this. Let's get a bit more personal on the constitution and the present crisis. Mr. Jasuya, I'm a voter of this country. So when I vote, I am electing someone that I want to represent me and my local constituency. So when my local representative, together with the other 224, come into parliament, they should decide on matters that matter to us, the people. But right now what we are seeing in the country is something that's totally different. It's about constitutional or unconstitutional. Let that may be. However, motions of no confidence were passed in Parliament. The Speaker took a voice vote and then also took an electronic vote about the motion of no confidence against the purported government of Mahinda Rajapaksa. But they still remain in power. What's happening?
This is total anarchy, an autocratic situation. I won't say even autocratic government, because there is no government in power. It has been further proven by the motion that has been passed in the Parliament today. It has been further proven beyond any doubt that the so-called government has no power or support in the Parliament.
And no majority.
No majority. How can they be passing legislation? How can they be passing budgets? How can they be passing vote on account? What happens at the cabinet meeting is not law. Cabinet meeting, whatever they can decide, is not law. Law has to be passed only in the Parliament. It is very clear that they have no power in the Parliament. Now people are saying, some people, many people, I have heard it from different quarters, whatever it is, now this has proven to a situation that we now have to go for general election. Yes, we have to go for general election, as provided for in the Constitution.
You're referring to the 4.5 years in power.
Yes. Constitution is the supreme legislation of the country. We can't, you and I can't decide, or no one can decide, not even the courts can decide that there should be an election today or tomorrow or yesterday, other than through the provisions of the Constitution.
That is because it is clearly said in the Constitution.
It is clearly said in the Constitution. Years. And what was there earlier situation was that there should be, the President had the power to dissolve the Parliament after 1 year. So that was made worse for the President, or made more democratic. That democratically elected government that has been put in place cannot be dissolved by the President on his own decision until and unless it passes 4.5 years. So it has been made more democratic and purposive. It is for that purpose that the constitutional, the 19th Amendment was brought in. So we can't go back on that. So that is, we can't defeat the purpose for which it has been brought in. So in fact, there is another legal maxim that I would like to make it more simplified. When interpreting legislation, there is a Latin maxim, a presumption, two presumptions. It says leges posteriores priores contra res. And also there is another one to say generalia specialibus non derogant, which means that the subsequent provision supersedes the earlier provision, right? Which means Article 70 supersedes the earlier provision, that is, which is a general provision which gives the power. Without that, if the Article 70 alone was standing alone, still one can argue that the President doesn't have the power to dissolve Parliament at all, or not even to prorogue parliament. This is the power that gives the enabling clause that enables the president to dissolve parliament or to even to prorogue parliament. And the circumstances are given and explained in Article 70. So there is no contrary view, there is no contradiction. It is both on the same line, and also we in our Sri Lankan courts, many a times we are quoting foreign judgments, foreign legal opinions. For some people, whenever it's not favorable, they say, no, we don't want foreign powers or foreign opinions or foreign interpretation. There is a very learned gentleman, Professor Emeritus Dr. Suri Ratnapala. He's a Sri Lankan Sinhala Buddhist. His father was also a famous senator and a Buddhist philosopher. He was giving his speeches and so on. He was the dean of the law faculty of the University of Queensland, and also he has been honoured by the Australian government for the contribution that he has made for the development of the Australian Constitution. And at that time when he was in the Attorney General's department, Mr. Shiva Pasupathy, the then Attorney General, couldn't go into court on any constitutional matter without the support of Mr. Suri Ratnapala. So he's such a learned person. He has gone through this matter and then given a very unequivocal opinion saying that this is totally wrong.
So before we get into another commercial break, let me ask this very quick question. If matters don't work out the way the people want it, the people have a right to change the government. The people, it's their right. It's their decision to change the government if things are not happening.
As provided for in the Constitution.
As provided for in the Constitution. But even if the Constitution is being abused, who do we look up to?
Courts. Whatever that may happen in the Parliament, I must bring this to your notice and the notice of the public. Whatever that may happen in the Parliament, the parliamentary proceedings cannot be controlled by the judiciary. This must be kept in mind. You may remember some time back, there was a impeachment that was brought against the then Chief Justice, Mr. Sarath Silva.
Okay,
Sarath and Silva. When that impeachment was brought against Sarath and Silva, he was the Chief Justice. What he did was he appointed another bench of judges presided over by the favourable judges who were there at that time, and he got another application filed before that bench and then got a stay order preventing the speaker from taking up that matter, the impeachment motion, for discussion in the Parliament. Mr. Andhra Bandaranaike was the speaker at that time. He made an announcement to the Parliament. There had been a stay order that had been conveyed to me. There has been a letter, some document, piece of paper he called it, that have been brought to me from the Supreme Court, where some 3 judges say that I've been prevented or restrained in taking up this matter for discussion in the Parliament. I have given it the due consideration. I have put it in the place where it belongs, the dustbin. That's what he said. The dustbin. He said, if they go beyond this, I will not hesitate to bring those judges to the well of the Parliament and deal with them. That's the way in which Mr. Andhra Bandaranaike treated this so-called order that have been given. Now, don't try to mix up the two. What is happening now is different. What is happening now is they are challenging.
My mind. I was going to ask that question.
They are challenging the dissolution by the president. They are challenging the dissolution by. This is not act of the Parliament. These are act of the executive. Act of the executive. It's an administrative act of the executive. Parliament enjoys special privileges that the president doesn't enjoy, because Parliament has certain privileges, but the president doesn't have those privileges.
Mr. Jasuvi, we'll talk about those privileges right after this break. Welcome back to the hot seat. So there are 2 different sets of privileges enjoyed by the executive and the legislature. Mr. Jasuvi, very briefly, can you tell us what those privileges are?
Well, whatever that has been said in the Parliament entails there is no action in tort, or where you can sue people for damages and things like that. Those are privileges. And in fact, parliamentary privileges are brought in by way of an act. When a member of Parliament is on his way to the Parliament and his way out of Parliament, he is again privileged, he can't be stopped.
Okay.
So these are basic privileges that are enjoyed by the parliamentarians. How they have been abused, I don't know. That's another matter for discussion. But the executive, the cabinet of ministers, they can be sued.
Right.
There are so many cases that have been filed in their capacity as the ministers of the cabinet. Now, even
But still, can they hide behind the privileges of being an MP?
no way, no way. These are administrative acts that have been committed by the ministers. So they have been challenged time and again. And now the immunity that was there on the president, not to be challenged for whatever the actions that he was taking as the president, have also been removed with the 19th Amendment. It's a very progressive act that has been brought in, part of the constitution. So even the president is not immune in certain matters where the Attorney General can be sued for the actions of the president. So we have moved forward. We have shred some draconian powers that were there vested with the president, including the power for dissolution, have been shredded. Now, in any civil society, one has to have respect for law. That is what we call the rule of law. If we don't have respect for the law, that's a huge problem. Let me quote from Edmund Burke, one of the philosophers in the 17th century. The danger of people crushed by law have no hope for what is right but for might. If laws are their enemies, they will be enemies to law. And those who have much to hope and nothing to lose will always be dangerous. And this is something that has to be kept in mind. These prophetic words of such people, though it's about more than 300 years old, this particular statement of Edmund Burke, who is highly respected personality, philosopher, they are most relevant even to the current situation.
And before we move on, Mr. Jasuga, just a question. Is the constitution being abused?
It's not the constitution being abused, constitution being misinterpreted by people to achieve the objective that they have in mind. That is not constitutional. It's not an abuse of the constitution. You throw the constitution away and then act on your own. That's not the abuse of the constitution. You are going on and then proceeding as if there is no constitution in the country. I can't say that's abuse of the constitution. The constitution is well and good. If there is a doubtful situation, that's a different matter, scenario. But here the constitutional provision is very clear. The purpose for which the 19th Amendment was brought in was, as I said earlier, was to shed the draconian powers that were there vested with the president. But is it been interpreted and then given effect to in that spirit? The spirit of the constitution is to reduce the powers of the president, not to enhance the powers of the president. Now, if you give this interpretation, the president will have the power to remove the prime minister even if he is elected and then sworn in soon after general election. Say 1 week after general election, it will take about 1 week anyway now after the results of the election, you swear in the prime minister and the cabinet. And then for some reason you don't like his face. Another week later, you can say, no, I'm sacking you. Has the president got a power like that? No, I can't call that an abuse of the constitution. That's a totally autocratic action that have been taken by a person in violation of the constitutional provision, in violation of the spirit of the constitution, defeating the democratic purposes for which it has been created.
Thank you very much, Mr. Upul Jasuga, for joining us on the hot seat here on News First. And we leave you with a very important thought. The will always overpowers the ability. Have yourself a wonderful evening.